Good morning. Welcome to Webb County Court at Law 2. I'm Victor Villarreal, judge of your Webb County Court at Law 2. This is the family law docket for Thursday, February 12, 2026. The time is now 9:20. Court is now in session. Assisting us today are Cecia Rodriguez, court administrator and interpreter. Ms. Cynthia Flores is the family law court coordinator. Video conference co-hosts this morning include Mr. Lopez, Ms. Ramos, Ms. Cuellar, Mr. Hernandez, and Ms. Rivera. These proceedings are being electronically recorded. Everyone is instructed not to record any portion of these proceedings. Only a court reporter may provide the official record. As with all proceedings, violation of these instructions are subject to contempt hearings. If you're joining us online, you're instructed to act as though you were in court because you are in court. The rule here is simple. If you would not do it in person, don't do it online. For example, do not operate a motor vehicle. There is no smoking, no chewing gum, wear appropriate clothing, and always exercise proper courtroom decorum. The court will now call the cases in the order of appearance of counsel, first those in person, and then those online, as measured by your login times. Ms. Flores.
First in person, Your Honor, is Attorney Claude Goldsmith, page 5, number 12.
Fernando Espinoza Jr. versus Samantha Espinoza, cause number 2025 FLAs 806C3. Court marks Mr. Goldsmith, present in person. Ms. Madeline Lopez Escoto, present in person. Good morning to both.
Good morning, Judge. Madeline Escoto for Ms. Espinoza. Judge, and Mr. Espinoza is present in person and will need the services of an interpreter.
Good morning, Your Honor. Claude Goldsmith for Mr. Fernando Espinoza, and we'll need an interpreter for him as well.
If it's okay for the parties to be in the center. Speak into the microphone and tell the court, are you Samantha Espinoza?
Yes.
Welcome to court.
Yes.
Your lawyer is on your left. Are you Fernando Espinoza Jr.?
Yes.
Yes.
Welcome to court. The court marks you present. Your lawyer is on your right. No more than 2 sentences at a time. Counsel, go ahead.
Judge, we're pleased to announce that we had gone to mediation with Judge Hale. And we had submitted to the court a mediated settlement agreement. Thereafter, some issues developed. However, Mr. Goldsmith and I have been able to resolve those this morning. And so we submitted to the court today in person an amended mediated settlement agreement. Mr. Goldsmith and I and the parties have signed off. There is a signature line for the court. And the additions in the resolution of this case have been initialed by Mr. Goldsmith and I. And we're asking that the court approve the same. The parties will stipulate as to jurisdiction. The parties will stipulate that the agreement is in the best interest of the children. The parties will stipulate that this is a just and right division of their estate. The parties will stipulate that they are being divorced on the grounds of insupportability with no expectation of reconciliation, and that no other child is expected of the marriage. The parties will also stipulate that Ms. Espinoza is not asking for a name change.
Mr. Goldsmith.
Your Honor, that is the party agrees, Your Honor. That's the agreement in full.
The court is ready to pronounce and render unless you have any questions for either client counsel.
No, Judge, the stipulations are pretty clear and they were included in the mediated settlement agreement.
Just couple of questions, either Mr. Goldsmith or Mrs. Cotto. How many children before the court?
2, Judge.
Ages?
7 and 16, yes. There's an older child, but that child is already an adult.
And genders?
Male and female.
Mr. Espinoza and Mrs. Espinoza, in your case, cause number 2025 FLA 806C3, the court at this time finds through your agreement, mediated settlement agreement and stipulations, the court finds that it has jurisdiction over this case, meaning this is the proper court form and venue to consider your divorce. The court finds that you entered into marriage, but that marriage unfortunately has become insupportable due to a discord or a conflict of personalities that destroys the legitimate ends of the marriage relationship. The court finds that there were 3 children born in the marriage. 2 children are minors. No other children were born, adopted, or are expected. The court finds that you have an agreement regarding your children. The court hereby adopts and approves your agreement and finds that it is, in fact, in the best interest of your 2 minor children. Likewise, the court finds that you have an agreement regarding the division of your property. The court hereby adopts and approves your agreement in full and finds that it is a just and right division. Ms. Espinoza and Mr. Espinoza, at this time, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced. The court has reviewed and signed your amended mediated settlement agreement. The court has signed it. The court is tendering the original to the clerk. These are now orders of the court. These orders are due to the court in the form of a final decree of divorce on or before
February the 23rd at noon by submission.
Anything else on this case, Mrs. Cotto?
Nothing further, Judge.
Mr. Goldsmith?
Nothing further, Your Honor.
This has now concluded your case. Mr. Espinoza, do you have any questions for the court?
No, sir.
Mrs. Espinoza, do you have any questions?
No.
I wish you both well, but more importantly, I wish your 3 children, adult and 2 minors, all the best. Good luck to all.
Thank you, Judge.
Thank you, Your Honor. That's all I have for the court today.
Good to see you, counsel. Have a great week.
Next case in person is Attorney Guadalupe Castillo, page 2, number 5.
Mauricio Salazar versus Cristina Alexandria Benedict, cause number 2021 FLC 1132C3. Good morning, Mr. Castillo. Court Martial present in person, Javier Guzman or Daniela Martinez. Any person from Guzman's firm present?
No.
Honorable Mr. Castillo.
See if the microphone is on.
There it is.
Go ahead.
Judge, we filed an agreed motion for continuance. The party for the petitioner has a medical appointment that she did not recognize last time. So we're asking for a reset. It's just one issue remaining.
Sure. Mauricio Salazar, are you present? Court marks Mr. Salazar not present. Are you Cristina Benedict?
Yes, Judge.
Welcome to court, Ms. Benedict. The court marks you present by video conference. Ms. Benedict, your lawyer has filed a motion for continuance. Since you're present, I must ask, do you have any opposition to the court granting this request?
No, Your Honor.
All right. The court has signed the order on the continuance, and the court has written in the court finds good cause due to counsel's unavailability. Ms. Flores, would you give us another setting, please? Oh, this is for temporary orders, so give us a setting in 2 weeks.
February 24th at 2 p.m.
Judge, I have a conflict. I have a jury case set for that week. Next week would be fine, if it's available.
I don't think we have any settings next week. Let me look at the calendar. Give me 1 second. I think we only have two options, Mr. Castillo, if that date is not available. It would either be one of my dockets on March the 5th, or next week would have to be heard by either an associate judge or a visiting judge on a criminal docket.
March 5 is fine, Judge. We'll try and work it out. It's
Sure.
only one minor issue. Then
Ms. Flores, give us the setting on the 5th that has the least amount of cases, AM or PM.
PM, Your Honor.
Go ahead.
March 5th at 2 PM.
All right. Any objection to that date?
No, Judge.
All right. Any other cases for Mr. Castillo?
That is all for Mr. Castillo.
Ms. Benedict, do you have any questions?
No, sir.
All right, we'll see you on March the 5th. Keep in contact with your lawyer, Mr. Castillo. It's good to see you.
Likewise, Judge.
Have a great day.
You too.
Next case, page 8, number 21, Attorney Jose Gabriel Lorel.
Vidal René Rodriguez versus Ilse Gonzalez Rodriguez, cause number 2026 FLA 98C3. Court marks Mr. Loredo, present in person. Good morning, counsel.
Good morning, Your Honor.
Vidal Rodriguez, Ilse Rodriguez, if you're present, please step forward. Are you speaking to the microphone and tell the court, are you Ilse Gonzalez Rodriguez?
Yes.
Welcome to court, Ms. Gonzalez Rodriguez. Court marks you present in person. Ms. Gonzalez Rodriguez, do you have a lawyer?
Not at the moment.
Will you be going forward today without a lawyer?
No, I have an appointment tomorrow with for a consultation.
All right, well, one more thing. Vidal Rodriguez, are you present? Court marks petitioner not present in person, present by video conference. Mr. Loredo?
Yes, Your Honor. Last time we were here, the respondent was ordered to see if she can get any documentation to prove that she was visiting with an attorney. I'm not sure if she has that with her or anything in writing or an email, perhaps.
So, Ms. Gonzalez, we'll just tell the court, between our first setting and this setting, what attempts, if any, have you made to look for a lawyer, talk to a lawyer, anything of the sort?
So the appointment was already set when we did the hearing on February 5th. I attempted to call her several times to see if there was any availability. There wasn't any. I also sent an email, which I have, and that's the only proof that I have.
All right, anything else?
Nothing further, Your Honor.
All right, Ms. Flores, give us that temporary order setting in 2 weeks.
March 5th at 2 PM.
All right, so we're last setting on temporary orders. We will hold a hearing on March the 5th. Please let that person, if you do hire that person, let that lawyer know that this will be heard by the court on March the 5th too. Do you have any questions for the court? Oh, Ms. Flores, does the court have Ms. Gonzalez's email address?
Yes, Your Honor.
Do you have any questions for the court?
No.
Good luck to you. Anything else on this case, Mr. Loredo?
No, that's all I had, Your Honor. May I be excused?
It's good to see you. Have a great day.
Likewise, Your Honor. Thank you.
Next, Attorney Madeline Escoto, page 7, number 18.
That is Arlene Caldera versus Marcos Caldera, cause number 2025 FLB 1441C3. Good morning, Mrs. Cotto.
Good morning again, Judge Madeline Escoto for Marcos Caldera.
Court marks you present in person. Juan Hernandez, are you present? Court marks Mr. Hernandez not present in person, not present by video conference. Arlene Caldera, Marcos Caldera, are you present? Court marks is not present in person or video conference. Mrs. Cotto.
So, Judge, we went to.
I'm present.
Oh, Mr.
Good.
Perez.
Are you Marcos Caldera?
Yes, this is Marcos
Welcome to
Caldera.
court, Mr. Caldera. Court marks you present. You're participating by video conference. Mr. Caldera, as you can see from your device, your lawyer is present in court. Caldera, are you present? Court finds petitioner Caldera not present. Mrs. Cotto, go ahead.
Judge, we attended mediation with Judge Hale earlier in the week. We recessed for Mr. Caldera to determine if there was something that he could do with regards to the last offer sent. Is that Mr. Hernandez? No? Okay. Okay. I
Mr.
thought it was
Caldera's
Mr. Hernandez.
device.
Okay. Mr. Hernandez was in federal jury trial, so Mr. Ornella stood in for him. Yesterday, I sent out a mediated settlement agreement, which is what Judge Hale had asked me to do, after we got the response from Mr. Caldera. I sent it to all parties. Mr. Hernandez advised me that he had just finished his jury trial, that he needed more time to talk to his client about this last proposal. And so we were wondering if the court would indulge us with a court setting next week, if you were available for entry. And I don't know why Mr. Hernandez is not here, because he said he would.
For entry of judgment.
Yes, because,
Wow.
yeah.
I guess the short answer is we can set it with Judge Letty Martinez.
We discussed that yesterday, if there was a possibility, and he had no objection to her.
Sure. So let's do. Yes, for court admin, I'm very surprised that Judge Letty has a setting next Tuesday.
I know I come back on the 24th, if the court still has that date available.
Let's do that. I think her calendar should be clear. I think she has one thing on the 17th, but probably needs that time. So let's do, if it's for entry, Ms. Flores, let's give this case Tuesday, February 24th at 2 p.m. for entry. However, in case it doesn't, give us a final hearing date after that.
It would have to be in February, Judge, because there is a motion to modify temporary orders.
Well, then let's give it that same day and call it both.
Okay.
It's final hearing and entry.
Thank you.
All right. Anything? Oh, Mr. Caldera, do you have any questions for the court?
No.
All right. Keep in
No,
contact
ma'am.
with your lawyer between now and when you come back on February the 24th at 2. Anything else on this case, Mrs. Cotto?
Not on in this case, Judge.
Good to see you, Mr. Caldera. I wish both you and Mrs. Caldera all the best. Have a good day.
Thank you.
Mrs. Cotto standing in for Ms. Julia, Ms. Claudia Lanese Garcia on page 3, number 7.
David Fernando Gallegos versus Jessica Gallegos, cause number 2022 FLA 1790C3. Court marks Ms. Marinel Lopez Escoto present in person on behalf of Ms. Garcia, Julia Rubio, David Fernando Gallegos, Jessica Gallegos. Is any other person present? Court marks no other persons present. Mrs. Cotto, go ahead.
Judge, Ms. Garcia advised me that the parties had filed the orders for the court's signature, and so they're requesting that the court approve and sign the same.
Court has received, reviewed, and considered the order and suit to modify the parent-child relationship. It is in due form. It is agreed to and signed by all counsel and parties. It is well taken. The court finds that it is in the best interests of these two children. The court has signed the original and is tendering the original to the clerk's office. And that concludes this case.
And that's all I have, Judge. May I be excused?
Have a great
Good to see
day.
you. Have a
Good
good
to see
weekend,
you.
Judge. Thank you.
Likewise.
Next, Mr. Maddox standing in for Ms. Julia Rubio, page 1, number 1.
Fernando Vasquez versus Yvette Josephine Vasquez, cause number 2003 CVG C3, court marks Mr. Edward Maddox standing in for Ms. Julia Rubio. Good morning, Mr. Maddox.
Morning, Your Honor. Edward Maddox, I'm here for Mr. Vasquez.
Are you Yvette Josephine Vasquez? I'm going to ask.
Yes, good morning.
Good morning, Ms. Vasquez. The court marks you present. You're participating by video conference. Ms. Vasquez, do you have a lawyer?
I do not.
Are you going forward in this case without a lawyer?
Yes, Your Honor.
Court marks you self-represented. Fernando Vasquez, are you present? Court marks Mr. Vasquez not present by in person and not present by video conference. Mr. Maddox, go ahead.
Yes, Your Honor. As the court knows, Ms. Rubio just gave birth and is on
A little closer to the mic, please.
Ms. Rubio's on maternity leave and is excused. I understand that she's excused from appearing except in urgent matters until, I believe, the second week of April or so. And I would like to ask for a reset. This case is a little bit odd. It was a divorce decree that was entered in 2004, and a quadro was submitted by Ms. Vasquez's lawyer, Oscar Vela, 20 years later, about 2 years ago. And the problem is Mr. Vasquez was not served with that quadro. There was no motion, and that order changes the disposition of a retirement benefit in conflict with the divorce. And so my impression is that the order is void because it didn't have personal jurisdiction. And Ms. Rubio's also filed a motion to clarify just so that we can get that in exact form. I'm gonna expect that she's gonna file a motion to amend her petition to add a motion to vacate and then be ready to proceed on that.
So, Ms. Vasquez, what Mr. Maddox is telling the court or arguing on behalf of Fernando Vasquez is that there was a finality to this case in 2004, but 2 years ago, I think your lawyer requested that the court sign a document that had to do with the retirement. Mr. Maddox, I guess, and Ms. Rubio are claiming that it is wasn't improper based on the court's rendition of this case, and he's asking for more time so that Ms. Rubio can finish her maternity leave. The thing is that between now and then, there's no changes. So everything stays the same until we come back. Do you have any response or objection to that request?
I don't have an objection to the request. However, just for note, that quadro was filed 20 years later because it was not included originally with the divorce decree, which is only a requirement on behalf of OPM. The division of the first benefits is stated in the final divorce decree for both of us. We're both government employees.
Yeah.
And so it is stated in there. The only difference is that OPM requires a separate quadro to be filed. And that's the only reason that that quadro was filed at that time. Because at that point when Mr. Vasquez was retiring, I received a letter from OPM essentially asking me for a quadro. And so that's why that was filed through your court, Your Honor.
So I don't know at this juncture what the truth is or what's going to happen. But what I do know is since Mr. Maddox isn't requesting that there be any changes, everything stays the same until Ms. Rubio gets back and argues and proves up her case through her client, and then you'll have that same opportunity to do so. But even if everything you're saying is true, just know that Mr. Maddox is making not only legal arguments, but factual. So just be prepared no matter what in any event. Mr. Maddox, remind the court, and I have it right here. Ms. Rubio's letter extends until April 16th, Thursday, April 16th. Ms. Flores, what date on a family law docket do we have after April the 16th?
Your Honor, actually, because of the issue, because the order remains in place, she specifically told me she would actually come back a little bit early on this particular one because we need to get, if we're right, we need to get because the payments are happening.
So you tell me, Mr. Maddox, I'm trying to accommodate Ms. Rubio's request.
She said starting the last week of March.
So give us a setting last week of March or as close to that date or thereafter, Ms. Flores.
April the 2nd at 9 a.m.
All right. Any objection to that date, Ms. Vasquez?
No, Your Honor, but may I make another statement?
You may. Go ahead.
So I just wanted to point out that the petition that I received, the petition to clarify, on there says that on page, what page is it? Page 2, section 6, where it says that since the date of the order, the several disputes have arisen between the petitioner and the respondent. That is a false statement. That I have not had any communication with Mr. Vasquez. He hasn't communicated with me or even his daughter for that matter for at least 2 years now. I have no idea why he would even take this route instead of just, reaching out to me. And as I stated before, I'm going to repeat, please. The only reason that quadro was filed 20 years later through your court was because I was asked by OPM to file that quadro in order for me to receive benefits which were awarded through the divorce decree, which was filed 20 years ago.
Well, two observations. First observation is that Mr. Maddox here did indicate to the court that Ms. Rubio would be filing an amendment. I don't know what that would include, and I don't know if that would resolve the issues that you were addressing, but the court did hear Ms. Flores, our court coordinator, say that the court has your email address, which means it's part of the filing system. So if the court needs to send you any information or notices, it'll go to that email address. Similarly, if Mr. Maddox or Ms. Rubio, on behalf of Mr. Vasquez, files any amendments, you're going to be served through that filing system at that email address. So take a look at that and see what's there. The other notation that I would make is if everything that Mr. Maddox is saying is true, and if everything that you're saying is true, neither one of you win because you still need evidence and testimony, and the court will hear that on April the 2nd. So just be prepared, look at your emails, review it, and be ready. One other observation, the court has heard everything you've said, but there's been a slight lag time during the last time that you were speaking. So just know that on the day of the final hearing, there's zero accommodations for your bandwidth. In other words, you come into court if you participate remotely with the bandwidth that you have.
Okay.
So either make sure that you're connected to a power source and you're not through Wi-Fi, but through a internet connection, or come in person to avoid that happening again.
Okay, Judge.
Do you have any questions for the court, Ms. Vasquez?
The date again, please. The date and the time.
Sure. It's April the 2nd at 9 a.m.
Okay. Thank you.
Anything else on this case, Mr. Maddox?
No, Your Honor.
All right, Ms. Vasquez, you're excused. Have a great day. Any other cases for Mr. Maddox, Ms. Maddox, or Ms. Rubio?
Yes, Ms. Maddox does have a case on page 4, number 11.
Oh.
Standing in for?
Is she here? Or are you sending in for her, Mr. Maddox? Well, let me call and we'll take it up. Page 4, case 11, Araceli Valdivia Martinez versus Raymond Lee Martinez, cause number 2025 FLA 223C3. Court marks Mr. Edward Maddox present in person on behalf of Ms. Maddox. Good morning, Mr. Santos.
Good morning, Your Honor.
Court marks you present. You're participating by video conference. Are you Araceli Martinez?
Yes, Your Honor.
Welcome to court, Ms. Martinez. The court marks you present. You're participating by video conference. As you can see and hear from your device, your lawyer is also present and participating by video conference. Raymond Lee Martinez, are you present? court marks Mr. Martinez not present in person, not present by video conference. We're set for entry of judgment and dismissal today. Mr. Santos, Mr. Maddox.
Your Honor, we have a working draft of a final decree of divorce. The only pending matter right now is the specific amount as to child support. This is a matter that we mediated, I think, 3 times with Judge Martinez. A divorce has already been rendered and pronounced on the record. We do not have any updated information as to Mr. Martinez, who recently took a new position with Geo. I've requested that information. In fairness, I asked for it yesterday due to illness. I wish I could have got to it earlier in the week, but I have not heard back as of date, understandably so.
I don't recall the specific instances or reasons why this case is set for dismissal, but it sounds like if you went to mediation 3 times, if there was a new position, whether there is or isn't, you don't go based on the information in the future, you go on the information that you have. And I guess that's why it may be set for dismissal. So I guess, Mr. Santos, Mr. Maddox, what good cause, reason, or basis is there to keep this case on?
I mean, I think that it's reasonable. I did not realize he had requested that information. Mrs. Maddox was out of the office yesterday afternoon, so she probably has not seen that. She had several other matters. So obviously, if child support was not settled in mediation, then we need to go through that, and it should be a relatively simple matter to just get it up to date. But we just need to pick a date where it's going to be calculated,
right,
and enter the decree as of that.
You go on the date of
people get new jobs and old jobs and raises and demotions and promotions.
I couldn't have said it better. That's exactly right.
Judge, when we entered into that agreement, it was envisioned that there was going to be the new employment. It hadn't started as of date. The understanding in the agreement of the parties was that it was going to be set based on the new financial information.
And so I won't opine on that. But I tell you what, look, there is work, there's change of circumstances. I may not agree what the calculation is, but at least there is work and communication. So I tell you what, I won't dismiss it, but let me just set this case to inactive. That way it's not dismissed, but I don't want to give it another setting because there's going to be more changes. And then I just don't want to put the parties or counsel in that position. You all just file in your order whenever it's ready. This case will be inactive till then. It's not dismissed, but you just file it whenever it's ready. Now, if you need a setting or any other request for relief, feel free to request it. So this case is hereby set to inactive for administrative purposes until the final decree is filed or until another request for relief is made.
That's perfect, Judge.
Yeah.
And Judge, just to make the court aware, we do anticipate that it should be within the next couple of days. We do have a pretty much final decree.
Sounds really good. All right. Anything else on this case, Ms. Ms. Martinez, unmute your device and tell the court. Do you have any questions for the court?
No, Your Honor.
Anything else on this case, Mr. Santos?
No, Your Honor.
Mr. Maddox?
No, Your Honor.
Any other cases for Ms. Maddox, Mr. Maddox, or Ms. Rubio?
That is all, yeah.
Have a great day.
That's a relief.
Good to see you. Have a great day.
Senor.
Next page, page 2, number 3, Attorney Quanka Garcia.
You said number 3?
Yes, on page 2, number 3.
All right. Raul Agustin Gonzalez versus Lizeth Lopez Gonzalez, cause number 2015 CVG 561C3. Good morning, Mr. Garcia.
Good morning, Your Honor.
Do you represent Ms. Gonzalez? Excuse me, Mr. Gonzalez?
Yes, Your Honor.
Mr. Garcia, the court marks you present in person. Speak into the microphone and tell the court, are you Raul Agustin Gonzalez?
Yes, sir.
Welcome to court, Mr. Gonzalez. Court marks you present in person. The person to your left is your lawyer. Good morning, Mr. Arce.
Good morning, Your Honor.
Court marks you present in person. Are you Lizeth Lopez Gonzalez?
Yes, Your Honor.
Welcome to court, Ms. Gonzalez. Court marks you present in person. The person to your left is your lawyer. Good morning to all. Counsel, what is the announcement?
Your Honor, Ruben Anderson for Ms. Lopez, Judge. We had filed a motion to modify and a temporary restraining order on this matter, Judge. I did speak to counsel. Mr. Garcia had noted that was coming in onto the case. Well, he just recently filed an answer. He was, my understanding, going to request some time, Judge, because he's coming onto the case. But in the interim, Judge, we did have some discussions as to the case, and we have come to an agreement to have Your Honor appointed ad litem. We do believe it's prudent, Judge,
in this particular matter, and we have agreed on an item as well, Judge.
You have an agreement as to that person?
Yes, Your Honor.
Oh, who is that person?
Elismar Soto, Judge.
Mr. Garcia?
That's correct, Your Honor.
And you're requesting additional time?
Yes, Your Honor.
By policy of the court, this is your first appearance on this case, well taken. So two things. First thing, Ms. Flores, give us a TRO setting, please. Oh, and this is also the first setting, so two good reasons to grant the request. Ms. Flores?
February the 24th.
Judge, I know that there was, I'm sorry to interrupt, Judge, but I know that there was a March date, Your Honor. Our hopes, Judge, this is in our opinion, a sensitive matter, is that Ms. Soto has enough time to talk to both parties and the child prior to us coming forth for the restraining order, Judge. We hope that maybe she can shed some light on some issues that are sensitive to this case, Judge. So I don't know, we could just have a little bit more time.
And if not, like perhaps perspective, and
Yes,
that would be good, and I agree with that. Any objection to the March setting, Mr. Garcia?
I don't know my client.
Sir, all I want is time with my daughter, sir. That's it. And the thing is that I understand the worries on this, but as to the statement made by
Well, I
sorry.
guess my client is saying if he would like to have it something if it could be late February or the first week of March.
sorry.
Give us that setting in the first week of March, Ms. Flores.
March 5th at 2 p.m.
Now, who here will be preparing the order appointing Ms. Soto?
I can prepare, Your Honor.
All right, so I will sign it as soon as it comes in. So just realize that it's going to take a day or two to get processed and then get sent back and then taken up by Ms. Soto and so forth. So just this, I'll add to say the sooner the better, so that Ms. Soto has sufficient time to reach out to Mr. Gonzalez, reach out to Ms. Gonzalez. Let me ask you all this. I don't know if you have considered Ms. Nelly Salazar. Because if you're concerned about time and the time the ad litem would need to, and maybe I'm just thinking outside the box, but the time the attorney ad litem would have to devote to the case, Ms. Soto's associate, I believe, is also taking appointments. So, well, it's your agreement to appoint Ms. Soto. I'll do that, and then you all can talk about any others associated with her office.
Yes, sure.
They may have more time. All right, Mr. Gonzalez, I've approved all requests. Do you have any questions for the court? All right, Ms. Gonzalez, do you have any questions?
No, Your Honor.
We would just be asking that the TRO be extended, Judge.
Any objection?
No objection, Your Honor.
So ordered. File it now. Sign the extension.
Yes, Your Honor, we'll submit that.
I look forward to hearing your case on March the 5th. Mr. Gonzalez and Ms. Gonzalez, I wish you both very well. Have a good day.
Thank you, Judge. Your Honor, that's all I have. Maybe excuse.
Good to see you, Mr. Arias. Have a fantastic weekend.
Likewise, thank you, Judge.
Any other cases for Mr. Garcia?
Yes, Your Honor. Page 1, number 2.
Maria Elida Moreno versus Antonio Alator III, cause number 2012, CVW 2193C3. Court marks Mr. Garcia present in person. Are you Maria Moreno? Speak into the microphone and tell the court, are you Antonio Alator III?
Yes, Your Honor.
Welcome to court, Mr. Alator. The court marks you present in person. The person to your left is your lawyer. Is anybody here on behalf of the Attorney General's office? So noted. One more time. Are you Maria Elida Moreno? One more time. Are you Ms. Moreno? The court has gotten a finger notation that says yes. Court marks Mr. Alator, is this your spouse, former spouse, or
Yes, Your Honor.
mother of your children? Court marks Ms. Moreno present by video conference. Mr. Garcia?
On this case, Your Honor, I was speaking to my client and he told me that he had reached an agreement, Your Honor. So we would just like to enter the agreement. I don't know if Ms. Moreno, I don't see her anymore, but my understanding was that they did have an agreement. as to the visitation, Your Honor, and that should take care of it.
Ms. Moreno, the court's about to hear an agreement. You're gonna need to be on video and audible for the court to hear you. No different from being in court.
It doesn't let me go back to the video call. I was in Zoom. It's not working. I don't know why it's not working.
It's working now. Just
it.
don't stop talking. Don't.
Not here. Can you tell them I cannot hear?
She can't hear you right now. The phone, the volume.
Who are
She's gonna
you?
try and connect to another phone.
Who are you?
Can you repeat that?
What's your name?
Jose.
Jose what?
I'm her son.
I understand that, but what is your name?
Oh, my whole name?
Yes, sir.
Maria Moreno. My whole name is Jose Sandoval.
Jose what?
Sandoval.
Jose Sandoval. Jose, is there any other person with you or Ms. Alator?
My little sister right now, my other brothers are in school.
What is your sister's name?
Alisa. My mom's logging into another phone right now.
I'm still asking, what is your sister's name? Alisa?
He's still asking. Can you repeat that?
Put the video in front of your face, please.
I can't, because I can't hear you. That's why I have it in my ear. She's in the waiting room.
I'm going to eject you from this hearing. All right. Court is admitting device Maria Moreno. Is that the first or second device, Ms. Flores?
I believe it might be the second device, Your Honor.
All right, someone has admitted, no more admitting. Court staff should monitor that device and prompt when available. Unmute your device, Ms. Moreno.
Me?
Are you Maria Moreno?
Yes, Your Honor.
Welcome to court, Ms. Moreno. The court marks you present participating by video conference. Who are all the persons that are with you?
My son, Jose Sandoval.
Any other person?
No,
Would it surprise you that he said that your daughter is also present with you?
she's sleeping in another room.
Understood. All right, I do this because if you're before the court, it's no different from you being right in front of the bench. And if you appear before the bench with other persons, then the court should know this. Court marks Ms. Catherine Garcia, present and participating by video conference on behalf of the Attorney General's office. Good morning, Ms. Garcia. Welcome to court.
Good morning.
Mr. Jose Garcia, would you tell the court the announcement and agreement, please?
Yes, Your Honor. Previously, Your Honor, we had temporary orders, and the temporary orders had Miss Moreno picking up the child Antonio Alator the 4th. It was every first, third, and fifth Friday. She would pick them up at 8 p.m. and then drop them off at Saturday at 5 p.m. at the McDonald's in Latonia, Texas. My client is telling me that the agreement for the final orders, Your Honor, that he has with Moreno is that it would be again standard visitation. However, it would be that she would pick up the child on Friday at 7 p.m. and then drop them off on Sunday at 7 p.m. And then it would continue being pickup and drop offs at the McDonald's that's on 709 North LaGrange in Latonia, Texas. And then all the other visits, the summer visits and holidays and everything would be in accordance with the standard position order, Your Honor.
For persons that reside more than 100 miles apart?
Yes, Your Honor.
Are there any other portions of the agreement?
No, that would be it. And then just that the parties continue using app close, Your Honor, to communicate.
Anything else?
No, Your Honor.
Mr. Alator and Ms. Moreno, I'm going to ask that you both raise your right hands. Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, Your Honor.
Honor.
Both have answered yes. You may both lower your hands. Is your true and correct name Antonio Alatorre?
Yes, Your Honor.
Mr. Alatorre, did you hear the agreement that was told to the court by your lawyer?
Yes, Your Honor.
Is that your agreement with Ms. Moreno?
Yes, Your Honor.
Is that your full agreement?
Yes, Your Honor.
Was anything left out?
No, Your Honor.
Is there anything you want to change?
No, Your Honor.
Do you believe that this agreement is in the best interest of your child or children?
Yes, Your Honor.
Same questions to you, Ms. Moreno. Is your true and correct name Maria Elida Moreno?
Yes, Your Honor.
Ms. Moreno, were you able to hear and understand the agreement that was told to the court by Mr. Garcia, Mr. Alatorres' lawyer? One more time, did you hear the agreement? There's no audio coming from your device. I'm about to approve this agreement without you unless you can fix your audio.
Can you repeat the question?
Did you hear the agreement that was told to the court?
I did.
Court has heard yes. Is that your agreement with Mr. Alatorre?
No, Your Honor.
That's not your agreement?
No.
Which portion of this statement is not part of your agreement, if any?
I'm sorry.
I'm sorry, say that again?
Can you repeat that?
Which part of the agreement is not your agreement?
I don't agree with the visitations or him having the right to get our son's primary residence.
Okay. If there's no agreement, you stick to the temporary orders until March 31st. All right, so your visitations continue to be limited 8 p.m., I think on Friday to Saturday at 5 with the exchange and McDonald's on Platonia, Texas, until further orders of the court, and that's likely to be on March 31st. Do you have any questions for the court? The court rejects your agreement in full and finds that there is no agreement. Do you have any questions for the court, Ms. Moreno? All right. You continue under the temporary orders with that limited visitation until further orders of the court. Do you have any questions for the court, Mr. Alatorre?
No, Your Honor.
Anything else on this case, Mr. Garcia?
No, Your Honor.
Anything for the court to consider, Ms. Catherine Garcia?
Good morning, Your Honor. The AG has nothing to add, Your Honor. The only thing is that the current order in place has a medical support of $25 a month, and we would ask that to continue.
Any objection by any person?
No, Your Honor.
All right, so ordered. I will continue. All right, Ms.
you.
Moreno, Mr. Alatorre, I wish you both very well. I will interview your child on March 31st at 1 p.m. and then go straight into your final hearing at 2 p.m. Good luck to all.
Thank you, Your Honor.
Thank you, Your Honor.
Next case from Mr. Garcia, page 6, number 16.
Jorge Zuniga versus Alexis Lizette Zuniga, cause number 2025 FLA 1658C3. Court marks Mr. Garcia present in person. Jorge Zuniga, Alexis Zuniga, are you present? Court finds no persons are present. Court takes judicial notice that respondent filed a waiver on November 21st, 2025. There is a final decree of divorce on file and an affidavit proving up jurisdiction signed by petitioner. Anything on this case, Mr. Garcia?
No, Your Honor.
But in this case, cause number 2025 FLA 1658C3 finds that it has jurisdiction over this case The court finds that the parties entered into marriage on October 23rd, 2010, but stopped living together. The court finds that there are irreconcilable differences that destroy the legitimate ends of the marriage relationship. The court finds that there was one child born in the marriage, no other children were born, adopted, or expected. The court finds that there's an agreement regarding the provisions regarding the child. The court hereby adopts and approves that agreement and finds that those agreements are in fact in the child's best interest. The court finds that there is an agreement regarding the division of property. The court hereby adopts and approves that division of property and finds that it is a just and right division. At this time, the court finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces the parties divorced. The court has reviewed not only the affidavit, but the final decree of divorce. It is in due form. The court has signed the decree, is tendering the original signed copy to the clerk's office, and this case is final. Any other cases for Mr. Garcia?
Yes, Your Honor, page 6, number 17.
Jorge Perez Jr. versus Norma Hernandez Perez, cause number 2025 FLB 1235C3. Court marks Mr. Garcia present in person. Melissa Saldana, are you present?
Yes, Your Honor. Good morning.
Welcome to court, Ms. Saldana. Court marks you present, participating by video conference. Speaking to the microphone and tell the court, are you Jorge Perez Jr.?
Yes, Your Honor.
Welcome to court, Mr. Perez. Court marks you present in person. The person to your left is your lawyer. Norma Hernandez Perez, are you present? Court finds respondent Perez not present. Ms. Saldana, Mr. Garcia, go ahead.
My client is on.
Excuse me. Ms. Perez, unmute your device and tell the court, are you Norma Hernandez Perez? Unmute your device, please.
Yes, sir.
Are you Norma Perez?
Yes.
Welcome to court, Ms. Perez. The court marks you present by video conference, as you can see and hear from your device. Your lawyer is also present by video conference. Mr. Garcia, Ms. Saldana, go ahead.
Yes, Your Honor. In this case, we did submit a Rule 11. We did reach an agreement, Your Honor, to the divorce decree. Your Honor.
That's correct.
Court has reviewed the settlement communication, now turned into a Rule 11 agreement. It is signed by both counsel. The court has signed off on it and approved it. Are you asking, I guess, just for an orders due date?
Yes, Your Honor.
Give us that date, Ms. Flores.
February the 23rd at noon by submission.
The only thing that could come back, Mr. Garcia and Ms. Saldana, is an objection to jurisdiction. Does someone want to prove it up, or does someone want the court to do so?
I can do it, Your Honor.
Mr. Perez, would you raise your right hand, please? Do you solemnly swear or affirm that the testimony that you will give in this cause will be the truth, so help you God?
Yes, sir.
You may lower your hand, Mr. Garcia. Go ahead.
Thank you, Your Honor. What is your name?
Jorge Perez Jr.
Okay, and you've been living in the state for the last 6 months?
Yes, sir.
And you've been living in this county for more than 90 days?
Yes, sir.
I don't have further questions, Your Honor.
Any cross?
No, Your Honor.
Court finds that it has jurisdiction. All right. Mr. Perez, the court has approved all of your agreement, which is now pending for the orders to be turned into the court. I'll sign off on those as soon as they come in, and that will conclude your case. Do you have any questions for the court, Mr. Perez?
No, sir.
Do you have any questions for the court, Ms. Perez?
No.
Anything else on this case, Ms. Saldana?
Yes, Your Honor. I'm just, I didn't hear, did the court pronounce and render the divorce?
I haven't, because it was only jurisdiction. Mr. Garcia asked on irreconcilability.
I can ask. Mr. Perez, and you're getting divorced from Ms. Perez based on the grounds of insupportability?
Yes.
And there's no expectation that you and Ms. Perez will get back together?
No.
I don't have further questions, Your Honor.
Ms. Perez and Mr. Perez and Ms. Perez, the court at this time finds that there is no reasonable expectation of reconciliation, and the court hereby renders and pronounces you divorced. These orders are due to the court on February the 23rd. Thank you for that catch, Ms. Saldana.
Thank you, Your Honor.
All right. Anything else from any person?
No, Your Honor.
No, Your Honor.
Mr. Perez, Ms. Perez, I wish you all the best. Good luck.
That is
Thank
all for
you.
Mr. Garcia. Ms. Saldana, for the
Good to see you, Mr. Garcia. Have a great day.
I'm here, Judge. Thank you.
Thanks.
next case, Mr. Del Barrio, page 5, number 14.
Adrian Garza versus Karim Verastegui, cause number 2025 FLA 1412C3. Court marks Mr. Del Barrio present in person, Mr. Ferreira present participating by video conference. Are you Adrian Garza?
Yes, sir.
Welcome to court, Mr. Garza. Court marks you present in person. The person to your right is your lawyer. Are you Karim Verastegui?
Yes, Your Honor.
Welcome to court, Ms. Verastegui. The court marks you present in person. As you can see and hear from this device, your lawyer, or that device, any device, all devices, I guess, in court. Your lawyer is present and participating by video conference. Mr. Del Barrio, Mr. Ferreira, go ahead.
Your Honor.
Good morning, Judge. I spoke to Mr. Montemayor, who's the litigant for this case. He's still pending to interview one of the children, and he was asking for some time to complete the report. I think he mentioned he was going to be unavailable today. We tried to get a Rule 11 on file, but I guess he was just unavailable for that. We would like to ask for maybe 2 to 4 weeks to give Mr. Montemayor enough time to complete that report.
Mr. Del Barrio?
Correct, Your Honor. I did speak with Mr. Montemayor, basically the same thing. If I'm not mistaken, I want to say that he's being sworn in today at the municipal court. I think I didn't get an invite, so I don't know.
I am in the same position.
Maybe not. I don't know. I heard something about that. But he said he was going to be unavailable. So I don't know if he meant like federal court or something, or he was doing something. But he did tell me the same thing. I heard that from somebody else, and I was like, "Hey, he didn't invite me."
Sounds like hearsay. Well, so the request is another setting. This is a first setting, and I think that would be reasonable and necessary. Any objection by any person?
No, Judge.
All right, so just give us the next trial of merits, so not only for that request, but this is the first setting, so it's a good request by policy of the court. Give us the next setting, Ms. Flores.
Yes, Your Honor, that'll be April 31st at 2 p.m.
Thoughts, comments, or questions, Ms. Verastegui?
No, Your Honor.
Mr. Garza?
Okay.
All right, so just make yourselves available to Mr. Montemayor. I think it's now optimistic. 2 weeks would be optimistic given his situation. He's about to get a little busier, if not today, relatively soon. The only other question I have, Mr. Del Barrio, you have a motion.
Oh, yes, Your Honor. Sorry about that. I do have a motion to withdraw. I have spoken with my client. I'm gonna, if I can, Your Honor, leave it with the court and not urge it at this time. But it looks like we've pretty much worked things out for now. I don't want to withdraw it just yet, but
sure.
I may. All right.
I tell you what, if you do need to urge it, just file a fiat before, I guess, at least a week and a half before April the 31st. That way, Mr. Ferreira has sufficient notice.
Yes, Your Honor.
And nobody can complain that they,
If it's urged, it'll be urged sooner. But I think we've worked things out.
It sounds like a good process. Mr. Garza, Ms. Verastegui, I wish you both very well. Have a good day.
Thank you.
Thank you, Judge.
Any other cases?
Thank you, Judge.
Good to see you, Mr. Del Barrio. Good to see you, Mr. Pereira. Have a great week.
Next case online, Your Honor, Attorney Melissa Saldaña, page 2, number 4.
Rogelio Saucedo Jr. versus Naila Guerra Ernesto Guerra, cause number 2016 CVG 1382C3. Court marks Ms. Saldaña, present and participating by video conference. Mr. Tames is also present and participating by video conference. Good morning to both.
Good morning, Your Honor.
Rogelio Saucedo Jr., Naila Guerra, Ernesto Guerra. Any parties present?
Yes. Mine should be yes.
Are you Ernesto, excuse me, are you Rogelio Saucedo?
Yes, Your Honor.
Welcome to court, Mr. Saucedo. Court marks you present by video conference. As you can see and hear from your device, so is your lawyer. Are you Naila Guerra?
Yes, Judge.
Welcome to court, Ms. Guerra. Court marks you present by video conference. Are you Ernesto Guerra?
Yes, sir.
Welcome to court, Ms. Guerra, Mr. Guerra. You're both participating by video conference, as is your lawyer. Court also welcomes Ms. Catherine Garcia, who's participating by video conference on behalf of the Attorney General's office. Mr. Tames, Ms. Saldaña, go ahead.
Good morning, Your Honor. Today, Judge, we have 2 motions before the court. We have a motion that my client filed asking the court to appoint a master in chancery, which we I think it was scheduled November 22nd, Judge, and it was passed because we were scheduled, or the parties had agreed to go mediate this matter. And we had gotten, I think, a date in January 22nd. So we said, look, let's pass it. Let's try to get everything resolved. But because of what I'm about to go into, I think it's necessary to take up that motion again. Because we also have pending today a motion to compel. So in preparation of this mediation, Judge, I needed some information that is solely in the possession and to which respondent has access to. So in order to be able to make an informed decision and to advise my client at mediation, I sent Ms. Saldaña some discovery back in November. I think that discovery was due December 26th. She was very prompt in getting that response, despite the fact that this was right around the holidays. However, it is scant. There was no document that was produced through our request for production. There were some interrogatories that I thought were disingenuous in the response. Certainly that is why we have now before you this motion to compel. And I've also added motion for sanctions. And the reason why I've added motion for sanctions on the respondent, Judge, is because we have now wasted, 2 months in which we could have been working to resolve this dispute. We were led to believe that we were going to go to mediation. As the court knows, we have to go to mediation with the information, the documents that will help us make informed decisions to efficiently dispose of cases before the court. Now, because of that has now been delayed. And so for that reason, Judge, we have those 2 motions before the court. I do have some background that I have added in case lines, Judge, as far as some documents, which I think will lend into going towards the motion for sanctions because of the disingenuous responses that we got in some of the responses to production and interrogatories. So before I go into those motions, I do want to go into that background. But that's what we have for you today, Judge. And whenever you're ready, I can get into it.
If I may respond.
This is just the background and framing of the issues. You may do the same thing. Ms. Saldaña?
Yes, Your Honor. There is a master in chancery and a motion to compel set for today. But in addition to that, our special exceptions are set for today. It is a final pretrial that was set November 22nd. So it is also set for today. And I am urging that be heard before anything else. And those are the special exceptions by my client, Ernesto Gera, who was never served, never given due process in the divorce. And so as far as the motion to compel, I did attempt to confer with Mr. Dames. I did explain to him that my client was in the hospital. She was having medical issues. However, and he said that he would delay that part, that he would only continue with the master in chancery. And then I have attempted to confer with him, but it seems that he's not willing to negotiate. And so that wasted time is not because of our doing, but because of the inability to be able to confer and work this out before, which I am still willing to do today. But again, before anything is heard, I'm asking for the special exceptions to be heard since my client was not given due process. In addition to that, just to let the court know, and I did call Mr. Dames yesterday to let him know, but I, again, couldn't get a hold of him. I filed a petition to quiet title. It has been accepted at the 406. And so that is involving the property that is solely my client's property. And that Mr. Saledo is claiming is his in the final decree. But the final decree order that orders this special warranty deed be signed by my client, Mr. Ernesto Gera, is our position is that it is a void order because he did not get he did not get due process. Therefore, the court lacked jurisdiction, personal and in rem, over Mr. Gera and over the property at issue today.
Lots to unravel. So look, without knowing anything else, this is the first contested matter, and we're getting close to the end of the docket. So it looks like we are going to get to this, and you'll have each and both have sufficient time to present whatever information, evidence, and testimony you want. But let me see if I can narrow this down, because I think both of you are right and both of you are wrong in certain respects. So this is the court's impression. The court has in its notes, and there must be a good reason. So I'm going to say this, and I'm going to need a response from the court clerk and coordinator to confirm the court's impressions. What I have on the court's docket is a final pretrial, the appointment for a master in chancery, and a motion to compel. I see the motion to compel the fiat signed. Two questions for the court clerk and coordinator, the appointment of a master in chancery, one, and the special exceptions. Are those set for today? And if so, how and where? Go ahead.
Your Honor, what we have set for today is the final pretrial. Motion for appointment of master and chancery, and motion to compel and motion for sanctions.
That was the clerk's office, the district clerk's office. That's the court's impression as well. I guess the first question, Ms. Alenia, the special exceptions, when were they filed and when were they set?
They were filed, let me get my early on. Let me see.
Your Honor, if I may,
Yes.
the special exceptions were said, but they were abated by Ms. Saldana. I believe it was back on November the 17th. On the hearing, she abated the special.
Okay, so once you abate, they just don't come back on sua sponte or by osmosis. You've got to either urge them on the record, and that's how they make it back on, or you file a fiat. So they're just not set for today. So and neither is the recent filing, which is the issue of jurisdiction. But it would seem to the court, Mr. Tames, that the court should at least hear that in some regard. I mean, it's not set for today. Let me be clear, and you have no notice that because it was just filed yesterday. As I'm looking at the docket. However, the jurisdictional claim, if true, two things on that. First, the jurisdictional thing is if true, would pop this whole thing, number one. But number two, if there is a setting in the 406 miscellanea, I can assure you this court is not going to wait for any other court. So you come to this court, and all persons, parties, litigants come to court, and whatever you can prove on the day that you can is what gets entered. And I think I just told other parties the same thing, Mr. Maddox and Mr. Santos. Things are always changing. So if there's some different rendition in some other court that affects the property here, this court just hears the facts and evidence and testimony on the date of the hearing, subject to other things going on in the future. So, and I say this because in other cases, other courts have taken years to resolve title issues. We're not going to wait years for that. So whatever you can prove on the date of the final hearing is what the court makes a decision on, absent good cause, basis, and reasons for extensions and so forth. And there may be. With that preface, let me hear from Mr. Tames and then a response from Ms. Alania as to this jurisdictional issue.
Yeah, I'm a little caught off guard because that's the court said this was just filed yesterday. So it's not set for today. Jurisdiction is a matter that can be taken up later. I will offer that Mr. Gara is before the court. He was served and he is here now. So I'm not sure what because I have not read the plea to the jurisdiction, but he served and he was before the court.
Well, in all fairness to the court hasn't either. I'm just learning about this now, and I always say this every time I look over here is because I'm looking at the docket sheet electronically to see what, when, where, and I'm trying to follow along with attorney argument. And I was looking over here as Ms. Alenia was speaking to see what was filed and when. That was just filed yesterday, so court hasn't seen it, let alone set it for hearing. So I guess, Ms. Alenia, response, if any, please.
Yes, Your Honor, thank you. I appreciate that. Yes, I did file a plea in abatement yesterday. However, it was a repetition of my special exceptions that were filed November 2025. And for Mr. Tames to say he's surprised, that's odd, since I have been arguing that my client Ernesto Gera never received due process. I have been arguing that from the start, and I filed that again November 2025, several months ago. So he cannot now stand here and say he's surprised, because that's always been the argument. My argument is that that one specific order ordering that Mr. Ernesto Gera sign his property, convey his property to other people that were not owners, That violates his due process. He never got notice. He never was a party. The property was not community property. And so it's void since the court lacked jurisdiction. Therefore, he cannot then continue with a master in chancery. Or his
So,
motion.
so let me do this at this juncture, because I don't know Mr. Tames's thoughts or what it is he's going to argue, what he's thinking, but I can only speak on behalf of the court. And I'm not going to say that the court is surprised. The court is just unaware of the recent filing, number one. Number two, if it is a repetition of arguments in the abate, in the special exceptions, then those were abated and waived back in November until refiled recently, and we're not set for that now. They can, however, be argued in the future. Knowing all of this, this is the first contested matter on the court's docket. Ms. Aldana, Mr. Tames, you're instructed to confer with each other until the court begins this hearing. I'm going to go through all the rest of the announcements, and then you can start arguing, but at least take the next few minutes to see if you can take 5 issues down to 4 or 3 or whatever the case is. So talk to each other. Before I release Ms. Catherine Garcia, anything to add on behalf of the Attorney General's office?
Your Honor, no, just to inform the court that on the child support issue, the AG's office does have a motion to enforce pending. It was filed in 2024. It is pending before Judge Mendez. It is currently set for hearing on March the 25th. There are child support arrears. The children both have emancipated, so there's no current support. And so, Your Honor, the AG's office does not have an interest in what is pending in this property division, the issues that are before the court. So we are not going to be participating here unless I can assist the court somehow.
The court always appreciates that. Thank you, Ms. Garcia. Ms. Aldana, Mr. Tames, confer, and I'll call this case momentarily.
Thank you, Your Honor.
Thank you, Your Honor.
Next case from Ms. Aldana, page 7, number 20.
Rebecca Isabel Cruz versus Humberto Magayanes, cause number 2025 FLE 1326C3. Court marks Ms. Aldana present by video conference. Mr. Rodolfo Santos also present and participating by video conference. Good morning to both. Rebecca Cruz, Humberto Magayanes, are you present?
He should be on Zoom. There he is.
I'm going to ask that you unmute your device and tell the court, are you Humberto Magayanes? Ms. Aldana, is this your client?
Yes, Your Honor.
Court marks him present participating by video conference. Rebecca Cruz, are you present?
She's not, Your Honor.
Finds Ms. Cruz not present. Counsel, go ahead.
Your Honor,
Yes,
we're set for final pretrial, and I'm not sure that there are any matters that need to be pretried at this time.
actually, Your Honor, I attempted to call Mr. Santos this morning. I spoke with my client and he does not want to agree to the termination after all. The last time we spoke, we were in court. There was that issue of whether or not an attorney ad litem should be appointed or a guardian ad litem because of the child's age. And so we're asking that. I think there is a need at this point because as I said, my client is interested in, well, not having the termination proceed or granted.
There's no motion for the appointment, but I know that it's inevitable. I'm not here to waste your time, Judge. If that's the case, if he's in fact going to contest, then we have no problem with the appointment at this time, being that, like I said, we anticipate it's going to be inevitable.
Mr. Santos and Ms. Aldana, is there any person that you agree to, or do you want the court to appoint the next person off the list?
If the court could appoint the next person off the list, Your Honor, I think that's probably best.
That's fine.
All right, who will be preparing the agreed to request and order for an ad litem?
Being that that the respondent's asking for it, Your Honor, I would insist that they please prepare that.
Any objection, Ms. Aldana?
We can prepare that.
I'm sorry?
We can prepare that.
All right. The ad litem orders are due to the court honor before
February 23rd at noon by submission.
All right, and then we'll come back to the petition to terminate on March 31st at 2. All
Very
right,
well.
anything else for the court to consider, Mr. Santos?
Not on this matter, Your Honor.
Ms. Aldana?
Not in this matter, Your Honor.
Mr. Magayanes, I wish both you and Ms. Cruz all the best. Have a good day.
Judge, I believe that's all I have before the court. May I be excused, Your Honor.
Good to see you, Mr. Santos. Have a great
Well,
week.
Ms. Aldana, God bless y'all. Thank you.
You too. Thank you.
Page 6, number 15, Attorney Rene Cantu.
Miguel Ángel Quanka versus Brenda Marie Quanka, cause number 2025 FLA 1624C3. Good morning, Mr. Cantu.
Yes, Judge. Good morning. I'm here.
Court marks you present. You're participating by video conference. Miguel Cuenca, Brenda Cuenca. Is any other person present?
They should both be on Zoom, Judge.
Court sees Brenda Cuenca's device is logged in. Court is asking to start video and unmute and making that request electronically now. Court sees Mr. Cuenca's device is also logged in. Court is asking to unmute and start video and making that request electronically now. Are you Miguel Cuenca?
Yes, sir.
Am I saying your surname right, Cuenca?
Yes, that's correct.
Welcome to court, Mr. Cuenca. The court marks you present and participating by video conference. Brenda Cuenca, please start your video. Admitting from the waiting room. Ms. Cuenca, please unmute your device.
Yes, just can you hear me?
Are you Brenda Cuenca?
Correct, yes.
Welcome to court, Ms. Cuenca. You're participating by video conference. Ms. Cuenca, do you have a lawyer?
No.
Are you going forward without a lawyer?
Yes.
Court marks you self-represented. Mr. Cuenca, one more time. Unmute your device and start your video and don't move the features or the buttons anymore. Mr. Cantu, go ahead.
Yes, Judge. So this is a divorce, Judge. I met with both parties yesterday at the office. We came up with an agreement. Basically, there's 3 kids of the marriage. The parties do stipulate to the jurisdictional requirements of the court. They both have lived in Webb County for more than 90 days. Both have lived in the state of Texas for more than 6 months. The agreement is that the parties have a community property home that will be sold and with the realtor. And the parties have agreed to child support. Mom will be primary, dad will be given standard visitation. Child support will start at $1,200 a month beginning in March. And everybody will keep their own accounts and their own things and their own names. Ms. Cuenca is also requesting a name change to Brenda Marie Morales. And we believe, Judge, that that's all we have for you. And we believe it's a just and fair division. And we're asking the court to approve it, Judge.
Mr. Cuenca, Ms. Cuenca, would you both raise your right hands? Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
Yes.
You may both lower your hands. Now that you're under oath, is your true and correct name Miguel Ángel Cuenca?
Yes.
Mr. Cuenca, you heard the agreement that was told to the court. Is that your agreement with Ms. Cuenca?
Yeah, that's the agreement.
Is that your full agreement?
Yes.
Was anything left out?
No.
Is there anything you want to change?
No.
The agreement regarding your 3 children, do you believe that that agreement is in their best interest?
Yes.
The agreement regarding the division of property, including your home, do you believe that to be a just and right division?
Yes.
Is there any reasonable expectation that you get back together or reconcile with Ms. Cuenca?
No.
And you heard the testimony. You've lived in Webb County and in Texas for 6 months before November 17th of last year?
Yes.
Is your true and correct name Brenda Marie Cuenca?
Yes.
Ms. Cuenca, you heard the agreement that was told to the court. Is that your agreement with Mr. Cuenca?
Yes.
Is that your full agreement?
I only have one request.
Is that your full agreement? Yes or no?
Yes.
Was there anything left out?
No.
Is there anything you want to change?
There's a request that I want to make, Your Honor.
What is that request?
So I'm requesting that the court awards me 50% of the community portion of my spouse 401k or retirement that was accumulated during our 19 years of marriage.
Your audio is muffled. It's loud, but muffled. The request is for
I'm sorry.
50% of a retirement?
Correct.
Of whose retirement?
1 second. Let me, so you can hear me better. Can you hear me?
Yes, your request is 50% of a retirement?
Correct. What was accumulated during our marriage of 19 years?
Judge, when I met with both parties, Judge, she said she didn't want any of that. She came to the office and said, I don't want it. I'm not even sure my client has retirement. I've never seen a retirement account, but that was not part of the agreement.
And this is something that you're requesting, Ms. Cuenca?
Correct.
All right, well, it sounds like you need time to figure stuff out, Mr. and Mrs. Cuenca, whether there is a retirement, there isn't a retirement, because if there is, you could be entitled to it, but if there isn't, you're making a request that is just hypothetical. So let me give you some time to do that. This is only a first setting, so I think it's good to give you more time. Your trial on the merits is now scheduled for
March 5th at 9 a.m.
Does the court have Ms. Cuenca's email address?
No, Your Honor.
What is your email address, Ms. Cuenca?
Brenda Marie 126 at hotmail.com.
There's many ways to spell that. So spell that spell the email address for us.
BRENDA MARIE 126 at hotmail.com.
All right, just be on the lookout in your email. If the court needs to send you any notices or information, it'll go to that email address. Likewise, if Mr. Cantu needs to send you any information or request, it's going to go to that email address. Mr. Cuenca, do you have any questions for the court?
No.
Mrs. Cuenca, do you have any questions?
No.
All right, I'll see you both on March 5th at
Judge,
9.
Judge, the only thing I want to say is I am probably going to be asking for attorney's fees against Ms. Cuenca. I have been here for 2 hours. She came to the office. We had an agreement. Now she's coming up with some sort of a retirement demand. I've never seen an account. I don't know if he has it. Maybe he does. Maybe he doesn't. We addressed it. She didn't want it. Now she is. So I was ready to go forward today with the agreement, but because of that, I am going to be asking for a demand for attorney's fees for wasting all my time here this morning, Judge. So I'm going to ask the court to take that up at the next setting.
Yeah, just file the request in writing.
I will, Judge.
Ms. Cuenca will get notice if you add her email address to the listserv, and
Yes,
then she can respond to that. Are you on this case, Ms. Garcia, Catherine Garcia?
Your Honor, the AG's office, we do have a case open for these children, but we did not intervene in the divorce. But if I could just make a quick announcement.
Sure.
I did not hear what the announcement was about an agreement on the medical support, but I would insist that there is appropriate medical support terms or language included in the final decree, as well as step downs. I believe there's 3 children before the court, and I only heard an announcement of 1 child support amount. So that's the AG's only request is that medical support be addressed, as well as step downs for all 3 children.
All right, so talk about that. And do you have any questions for the court, Mr. Cuenca?
No.
Mrs. Cuenca?
No.
Anything else on this case, Mr. Cantu?
No, Judge, I'll go ahead and serve Ms. Cuenca with that demand. And also, Judge, the court date, the next one would be March 5th.
March the 5th at 9 a.m.
Got it.
All right.
Thank you, Judge.
I wish you well, Mr. and Mrs. Cuenca. Any other cases for Mr. Cantu?
That is all for Mr. Cantu.
Have a great day, Mr. Cantu. It's good to see you.
Thank you, Judge. Likewise. Thank you, sir.
Next case, page 3 and 4, Attorney Leticia Garcia.
These are, I think, companion cases. Alicia Karina Barola versus Luis Antonio Ariaga. Cause numbers are 2023 FLI 681C3 and 2025 FLA 1647C3. Good morning, Ms. Garcia.
Good morning, Judge.
Court martial present participating by video conference. Oscar Vela, are you present? Court martial, Mr. Vela, not present. Court
Your Honor,
martial.
he's in federal court at the moment.
Catherine Garcia present by video conference. Alicia Barzola, Luis Arriaga. Any other person present? Court finds no other persons present. Ms. Garcia, go ahead.
Yes, Your Honor, these are the two companion cases. The suit affecting parent-child relationship initially filed by Mr. Vela and his client, and the divorce following by myself. We're asking Judge that the court give us a date for both cases at the same time for the latter part of April. We're in the process of discovery, and it seems that we might have an agreement. In the event that we don't, after the discovery responses are tendered, we will, and we're agreeing to go into mediation if necessary. We don't at this point think that that's going to be necessary, Judge, but by the same token, we'd request that extra time so that we can combine all of our discovery requests and answers to each other. We're going to sit together also, Judge, with regards to both cases. So if that's acceptable to the court, I request sometime late April.
Well taken on all regards and all fronts.
Thank you, Judge.
First thing, Ms. So are you requesting that the court remove from its docket the March the 5th setting and just give you a late April?
Yes, Judge. We realized that the last setting, which was just literally about a week to 2 weeks ago, if the court recalls, we had just combined both cases so that they can run concurrently on the same dates rather than all these other dates going on with both different cases.
Well, it sounds like what the court did is that it just set them on the same docket, but Mr. Vela just yesterday filed a motion to consolidate.
Correct, Judge. And we've got some discovery responses that we have to propound to Mr. Vela and his client. It's not many issues, Judge. It's literally a home that is in both names at this point. My client is residing in the home, paying all the payments, all the property taxes, and she's got the 2 minor children. There is 1 adult child who is currently at the University of Houston, and the house is in both names.
Right.
So
if there's no objection to the consolidation, is there an objection to the consolidation?
there's not, Your Honor.
All right, the orders are due on the consolidation on or before.
February 23rd at noon by submission.
And the final hearing in April is on, you said late April, is that what you said?
Yes, Judge, please, so that we can maybe go to mediation if necessary.
Sure.
April the 28th at 2 p.m.
All right. And both cases are set because they're now consolidated. All right. Any other cases for Ms. Garcia?
That is all.
It's good to see you, Ms. Garcia. Have a great
Thank
weekend.
you, Judge. Likewise. Have a good day.
Thanks.
Next case, Attorney Alberto Martinez King, page 5, number 13.
Carlos Misael Gloria versus Wendy Anaí Gloria, cause number 2025 FLA 1213C3. Good morning, Mr. Martinez King.
Good morning, sir.
Court marks you present. You're participating by video conference. Victor Villafranca, Attorney Villafranca, are you present? Court finds Mr. Villafranca not present. Carlos Gloria, Wendy Gloria, are you present? Court finds neither party present. Counsel?
Mr. Villafranca advised us that he had a court at the same time as this one, and we filed an agreed motion for continuance.
Court finds that counsel unavailability warrants granting the request. The request is well taken and granted. Ms. Flores, give us another setting, please.
April 2nd at 2 p.m.
Any other cases for Mr. Martinez King?
That is all.
It's good to see you, Mr. Martinez King. Have a great rest of the day.
Likewise, thank you.
Your Honor, would like to go down the docket?
Court will call yes, ma'am, thank you. Court will call the rest of the cases as the cases appear on the docket. Page 3, case 6, Samantha Soto Rios versus Julio Cesar Patinho II, cause number 2022 FLA 126C3. Philip Del Rio, Jose Tellez, Samantha Rios, Julio Patinho. Any person present? Court finds no persons present. The court has seen that there is a request for non-suit. However, the court has signed an order that only non-suits the current request, not the entire case. Court has signed that, so this case is now inactive. Page 4, case 10, Julio Cesar Villasana versus Joanna Elizabeth Rangel, cause number 2024 FLC 1931C3. Javier Montemayor, Julio Cesar Villasana, Joanna Elizabeth Rangel. Any persons or lawyers present? Are you Julio Cesar Villasana?
Yes, Your Honor.
Welcome to court, Mr. Villasana. The court marks you present in person. The court finds there are no other persons present. This is a final pretrial. Let me ask the clerk's office, was anything filed for the court to consider at this hearing?
That was the only thing that was filed on January the 16th, 2026.
And that was?
The proposed temporary order and proposed order of
But was a hearing held on the temporary orders?
Mr. Montemayor needed to refile the orders, Your Honor. I don't believe those are the correct orders.
I think that's why the court hasn't signed off on them. All right.
Yes, Your Honor.
And as to the attorney ad litem, I guess if that's the only thing for the court to consider, the court will grant without objection. I will pick the next person off the list and then appoint that ad litem. All right, if that's the only thing for the court to consider, the court will do that and we'll come back for the final hearing on April the 16th at 2. Mr. Villasana, do you have any questions for the court?
No, Your Honor.
Court will sign the next person off the list and I'll call this case on April the 16th. Mr. Villasana, I wish you well.
Thank you.
Have a good day. Page 7, case 19, Joseph Alexander Requena versus Itzel Tobias, cause number 2025 FLC 1063C3. Javier Montemayor, attorney Montemayor, or parties, Joseph Requena, Isabel Tobias. Any persons present on this case? Court finds no persons present except for the Office of the Attorney General, represented by Ms. Catherine Garcia. Was anything filed on this case?
this one, Your Honor. An intervention was filed by AG on October the 31st. And then we just have service.
It was filed last July. I tell you what, let's do this. Give us one more setting and dismissal date. So give us a setting in April and dismissal in May.
That would be April the 2nd at 2 p.m. Dismissal will be May 5th at 2 p.m.
So ordered. Any objections to any of this, Ms. Garcia? All right, without objection. All right, that leaves just one contested case on the court's docket, does it not?
Yes, Your Honor.
All right, Ms. Saldana, Mr. Tamez, the court is going to call this case very momentarily in a few minutes. Court is going to stand at ease for a few minutes. You'll go straight into your case and the court has a hard stop at 11:50. Stand by, please. All right. court is back in session and we are on the record. This is Rogelio Saledo Jr. versus Naila Guerra Ernesto Guerra, cause number 2016 CVG 1382C3. Present and participating by video conference are both counsel Francisco Tames and Melissa Saldana. Also present and participating by video conference are the parties, the litigants, Rogelio Saledo Jr., Naila Guerra, and Ernesto Guerra. I need all persons present to turn on their videos, start their microphones so that we can begin. All right, all persons are present and connected to video and audio. Mr. Tames, these are your motions. Which one will you be presenting and arguing first?
Your Honor, I actually was going to call Miss Naila just to confirm a response I was going to give Mr. Tames on the motion to compel. And I think it'll resolve that issue.
I'm sorry, you're gonna call Mr. Tames?
I was gonna call Miss Gera to make a recommendation, which I think will resolve the issue of the discovery motion to compel.
Ostensibly the Mansory and Chancery issue as well?
Not that one.
Mr. Tames?
Your Honor, we conferred pursuant to the court's instructions, Ms. Saldana and I, and we went through some of the discussion, some of the arguments and positions that both sides have. And based on the discussion that she and I had, she was going to call Ms. Guerra to confer with her if she's willing to produce the information, answer the ROGs, and produce the documents that we've requested. And that's where we left off.
All right, so the court will stand at ease for you to have the conversation. Ms. Saldana, just keep in mind the court has a hard stop today at 11:50. I mean, we can go on after lunch, I guess, but I mean, try to see if we can wrap this up before 11:50. So I tell you what, let's all turn off our videos and cameras. When you come back on video, court staff will let the court know that your client has had sufficient time to contemplate the proposal and you have a response.
Yes, Your Honor. Thank you.
All right, we stand at ease. court is back in session, and on the record, this is cause number 2016 CVG 1382C3 Saledo versus Gera and Gera. Counsel Tamez and Saldana are present by video conference, as are the parties. Ms. Saldana, Mr. Tamez, what, if any, is the announcement?
Your Honor, I'm happy to report that Ms. Saldana and I have been able to reach an agreement on the motion to compel. Ms. Saldana and her client have agreed to withdraw their objections and produce responsive documents and answers, documents to the extent they have those in their possession and access. We've agreed that they would have until February 26th to produce those documents and to answer those interrogatories and requests for admissions that were part of the motion to compel. And that is the agreement on the motion to compel. On the motion to appoint master in chancery, we don't have an agreement. I think procedurally, there's other things, as Ms. Saldana pointed out, that she has now taken some steps. So I'd rather move forward on that now. And then once we get an order, if the court agrees with my position, then we can discuss what we do then.
Thoughts, comments, response, or objections before we proceed on the motion on the master, Ms. Saldana? Please unmute your device.
That is correct, Your Honor. It was just on an interrogatory number 18 that we addressed that it was none. But the rest, yes, we will.
I'm sorry. Yes, you're absolutely correct. On that one, the response was none, and I mistakenly put it in my motion to compel, but that is correct.
So just one point of clarification, because I don't want any person on one side or the other to get hung up, and this always happens in 98% of cases. So, Ms. Saldana, the agreement to produce documents, I heard Mr. Tamez tell the court if they're in your client's possession, I guess, or ostensibly in their control, that you wouldn't produce. Now, would you just not be producing, or will there be an affirmative statement saying something doesn't exist or not in the possession? In other words, I don't want you to get caught up on either side to where Mr. Tamez comes back and says they didn't produce, and you would say, well, that's because we don't have it or we don't control it, and it's not clear as to that's the position.
Right. So we will produce what they have. So if it doesn't exist, we'll just let him know there's none. You know,
I guess what the court is saying, can you put that in writing? That way it's crystal clear and there can be no dispute in the future as to what your client's position is. Because I don't want anybody guessing that it doesn't exist or it's not in his control or something else. In other words, save yourself both the headache, time, and expense in the future by just being clear as to the non-production, if there is any.
Yeah. Judge, in my request for production, in my written discovery, I'm very clear to define what it means to be in possession, custody, or control. And so to the extent that the response states we neither have possession, custody, or control of the item because it no longer exists or because we never had it, that's fine. I'll put an order and I'll be explicit in that order, Judge, and I'll confer with Ms. Saldana on the order before we submit it for your consideration.
I know, but Ms. Saldana, is there any objection to that? Just being explicit about if there is any non-production, you'll just say whatever the reason for the non-production is.
right. There's no objection. We'll say if it doesn't, yeah, we'll be transparent.
Yeah. Well taken and so ordered. Mr. Tamez, as to the master, go ahead.
Yes, Your Honor, thank you. Judge, as the court is aware on this particular divorce that was signed by Your Honor back in 2017, the parties and the property for the court was obviously community, right? The court has jurisdiction in a divorce to divide the marital estate, the community property of the parties. On page 29, the court explicitly and the parties sign off on this and agreed. The court says it is ordered that the party shall continue to lease 5300 Cypress Drive, apartment 37, Laredo, Webb County, Texas. The proceeds of the rent monies shall pay the mortgage, taxes, and insurance. The party shall be equally responsible for half of the cost of any repairs and maintenance associated with the property. It is ordered that Ernesto Guerra shall sign a special warranty deed awarding the property to the parties in equal shares. The affirmation, Judge, of the parties' agreement under oath, Ms. Guerra stated that she agreed that this was a parties agreement, that she understood that this was the parties agreement, and that she was going to comply with the parties agreement. She was asked under oath, is there anything else you would like to add? And she said no. Now, all these years later, Judge Ernesto Guerra never signs a deed conveying title to the property to Ernesto Guerra and to Ms. Guerra, excuse me, to Mr. Saledo and Ms. Guerra, as ordered by the court, as agreed to by the parties, as stipulated on the record under oath. Now, as the court is aware, Judge, Texas recognizes title ownership and equitable ownership. And in many instances in our legal history, equitable ownership has taken higher precedence over title ownership. Title is just one incidence of ownership, while equitable is the prelude by which the courts then establish actual and complete possession and ownership. And Judge, I mentioned that the court obviously could only dispose of community property. The parties subjected that community property to the court, and under the divorce, the court made the decision, the division. I refer the court to the case of Haynes versus Molina. This is a Court of Appeals case from Houston, September 14th, 2021. It's Lexus number 7564. And in that particular case, Judge, the court refers the parties to Longoria versus Lassiter, and that is 292 Southwest 3rd, 156 at 165. That is actually from the Fourth Court of Appeals just up the road. And it refers to the Longoria case to say legal title shows apparent ownership, but it does not necessarily signify full and complete title or beneficial ownership. As the courts in Texas recognize, equitable title refers to a person's beneficial interest that entitles the person to acquire formal legal title. And that's exactly what the parties contemplated in the divorce decree. That is exactly what the respondent stated under oath was the agreement. And that is why it is incumbent that we proceed to have this master now comply, because Mr. Guerra will not. And I will offer to the court that at the time, even though I don't think it's relevant to the request for the master appointment, but at the time, the parties knew that the down payment to purchase the apartment was community property, that the payments to pay the mortgage was community property. And so equitable ownership clearly and unequivocally, at least under oath, by the court's own order, stated that they were going to be divided 1/2 ownership. And all we needed to do was to have the title vest fully what the court and the parties recognized was lawfully theirs, that they were the owners of this apartment. And so for that basis, Judge, because of this continued obfuscation, we asked the court to appoint a master in chancery, which the court has legal right to do, to sign a deed that conveys what the parties agreed to, what the court ordered them to do, convey title, and rest it and merge it into the equitable title that the parties have. 1/2 to Mr. Saledo, 1/2 to Ms. Gera.
I see. Anything else?
No, Judge.
Ms. Saldana?
Yes, Your Honor. First, I would like to ask the court to take judicial notice of the file and the final decree, all the pleadings, all the motions, everything that was filed in that case.
Without objection, notice so taken.
Thank you, Your Honor. Also, I would like to point out that throughout the argument or opening, I suppose that was made by Mr. Tamés, not once was it stated that Ernesto Gera was made a party to the case, that Ernesto Gera was given notice of this case, that Ernesto Gera was ever involved in any way in this case. He wasn't served. He wasn't given the due process that one must have in order to have their real property divested. There is a deed from 2008, which shows that he was the sole grantee of the real property at issue here. And Now, what's being argued is that there is equitable title vested in Mr. Salcedo and Ms. Guerra. However, the divorce decree doesn't make any findings that there was in fact equitable title. All it states is that the property should be awarded, the husband should be awarded half of what he owns and wife should be awarded half of what she owns. But our position is they didn't own anything. And there may have been a way to do this, but it wasn't included in the divorce decree. And so because of that, but more importantly, because Ernesto Guerra was not given due process, then the court could not divest him of his real property. That's in violation of the Texas Constitution, Article 1. And therefore, I would cite the Texas Code, Section 9.401, where a court would lack jurisdiction because they didn't have personal jurisdiction. So because they didn't have personal jurisdiction, and our position is that they also didn't have in rem jurisdiction, then the decree is void, at least that portion of the decree, because of this lack of jurisdiction over Ernesto Guerra. And so because that, our position is that that portion of the decree is void, then a master in chancery based on that one clause or one order cannot be granted.
As you're arguing, I'm reading your plea. I guess let me ask you both this, because what's apparent to the court so I just read the plea in abatement, and it's based on the filing of a district court case. But it isn't clear to the court, Ms. Saldana, if your client's position is that this court lacks jurisdiction for no notice or service. I don't know what I really don't know, because it doesn't say in this plea if the claim is on the enforcement or on the original action.
It's on the original action. And because it's on the original action that has the order, then the enforcement could not proceed since that order.
Tell me the date of the signing of the final decree.
That was March 2017, I think March 16, 2017.
All right, let me look for that document.
March something.
Correct, Your Honor. Actually, it's May 16, 2017.
Oh, I'm sorry. I thought it was March.
I see. The original parties, excuse me, now I understand. So the original parties were Rogelio Saucedo and Naila Guerra. They're the divorcing parties.
Yes.
Correct.
You're saying, Ms. Saldana, that Ernesto Guerra wasn't served, and he is somehow either equitable or actual title or owner to this property.
Correct.
But your position here isn't that Naila Guerra is in no way an owner of the property.
My position here is that the decree did not make a finding that she was an owner. So my position is,
I'm sorry, say that again?
that there's nothing in the divorce decree that states that she was an equitable owner, but additionally,
But did the court divide the property? Did the court in its final decree divide the property?
Yes, yes.
How would the court not divide it unless the court found that it is community property?
Right, but my second part is that Ernesto Guerra was never involved. He was divested of this property without his involvement, without him being served, without him being made a party. So Miss Guerra and Mr. Salcedo did what they did. The court, just listened to them.
I think so. Having heard all of this, I think you're going about it the right way, but in reverse, right? So a party can't complain that they didn't get served if they're before the court. It sounds like, all right. So let me do this first. Ms. Salanya, other than Mr. Guerra not getting notice, and I don't think there's a dispute on that. What argument is there not to appoint a master?
Yes, Your Honor. My client Ernesto Guerra, by appointing a master, will be divested of his real property. But in order to be, according to the Texas Constitution, to be divested of his real property, he needed to have gone through due process in the original order
That's a presumption that the court can't make. In other words, is there any information in the record that allows the court to make a finding that Mr. Guerra is in fact a legal, actual, or equitable owner of this property?
There's a deed that was filed at the beginning of this case, a deed that shows that he is the 100% owner.
So then why would you go to another court to make that determination? It sounds like that court may not have jurisdiction, because if this court, under its family law jurisdiction, has the authority and legal ability to make dispositions on that property, and in fact, if Mr. Guerra knows about it, and ostensibly he does because he's here before the court, and then sits on those rights and this court makes an order, it sounds like he may be waiving right to complain later. It sounds like, without knowing anything else, I'm just making observations. I'm not making any rulings right now. So I tell you what, if the only issue before the court is whether to appoint a master, then I think at this juncture, the court can find, based on the argument and position of Ms. Saldana and the argument and position of Mr. Tamez, and having taken judicial notice as requested by Ms. Saldana, the court can find that there, one, this case is exceptional for the reasons stated by both counsel, and two, the court finds that there is good cause for the appointment. Having made these two findings, the court is going to order and instruct Mr. Tamez to prepare an order that appoints a master with those two findings, and that order is due to the court honor before
February 23rd at noon by submission.
Now, having noted all of this, in other words, and by the way, Mr. Guerra, Ms. Guerra, Ms. Salcedo, I believe, I wouldn't say any of this unless I absolutely believe that this is the true and correct, just and right finding under the law. On top of all of that, I have probably just saved you about $12,000 and many months of court hearings to get through this process, just as an added benefit. And talk to your lawyers about that. Having said all this, Mr. Tamez and Ms. Aldana, who, if anyone, can you agree to, or who do you suggest could perform this work?
Your Honor, maybe Robert Saldana, Sigfredo Perez, both practice a lot, primarily, extensively in real estate, and could certainly prepare that. I think the court had mentioned Judge Hale previously. The parties had agreed to mediate with Judge Hale. So if Ms. Saldana doesn't think that there's a conflict for him to simultaneously serve as the master and a future mediator in the case, then that would be another choice.
I would object to Judge Hale because of the mediation, but I'm not going to agree to anybody because, again, my client's position is that he did not get due process and is still opposed to this ruling, to the findings.
I understand, and that's a reasonable position well taken. I also think and know that Judge Hale, for mediation and different appointment reasons, may be pressed for time. As to the other two suggestions, without waiving your objection is lodged and it's not waived. Ms. Aldana, do you want to chime in on the other two before the court makes a decision on either?
I do not.
All right. Mr. Tamez, Ms. Aldana, I am familiar with the work of both Mr. Saldana and Mr. Perez. I'm familiar with Mr. Saldana's work in real estate and Mr. Perez's work a little bit in real estate, but more in civil litigation. And it sounds like the better fit for this case may be Mr. Perez. So the court will appoint him. And the court will appoint him with the specific duties given to the master. The specific pending matter is the request stated in the master and transferee that includes, but isn't limited to, the specific matter of addressing the real property concern in this case. That's now subject to another lawsuit, I guess. All right, those orders are due to the court honor before February the 23rd by submission. Anything else pending on this case, Mr. Tamez?
Judge, as far as costs, does the court want the parties to equally borne the cost? The property was to be equally divided between the parties.
Without knowing anything else, this is your time to chime in. Any thoughts, response, comments, or objections to that request, Ms. Aldana?
Yes, Your Honor. I would object to, of course, to that request. I would ask that Mr. Saledo bear the cost, but additionally, if the court does want to divide the cost, I would ask that my client, Mr. Ernesto Gera, be left out of that requirement, since, again, our possession is that he was never served with a divorce. And
You said he
rest
was served with the divorce, Mr. Tamez, but was he served in this case?
He was, Your Honor.
So he is a proper party in this case at this juncture.
So, Your Honor, if I may, he is a proper party in the enforcement. However, the enforcement is based on a divestment order, which was where it lacked due process, to give him due process. He did not get due process for them to say, we're going to take away your property. You have to sign away your property. But now that is the basis of the enforcement. And that is the basis of the
it just dawned on me, Ms. Aldana, that even if everything you're saying is true, Mr. Gera still doesn't win because you're not attacking the final decree. In other words, nothing, if the court even grants your request, undoes the decree. That's still valid, legal, and enforceable. I was about to say that it should be split 50-50, except that now Mr. Gera is a party separate and apart from your other client, Ms. Gera.
So, Your
Ms.
Honor, if I may, it was a fundamental error. Therefore, it's a void judgment, at least that part of the order. Because again, he did not get due process. So because it is a fundamental order, I can raise that argument at any point. So I can argue that it was void, and I am arguing that it is void.
I've heard that and I understand that, and I appreciate the argument. I tell you what, without knowing anything else, since this is really a matter for you to prove misalignment. So at this point, this is still until the master figures this out and makes some decisions and prepares a report to the court. This is still a petitioner respondent, former husband, former wife. So the court is going to split that cost 50-50 until the master submits a report making a finding that there's actually 3 persons that are involved in this case. And then you all can make different arguments if you choose to do so. But right now it's Mr. Saledo and Ms. Gera that are responding. It's their divorce. All right, include those in the orders. Anything else on this case, Mr. Tames?
No, Your Honor.
Ms. Aldana, anything else?
No, Your Honor.
Mr. Saledo, the court has made a number of decisions today. Do you have any questions for the court?
No, Your Honor.
Ms. Gera, unmute your device, please, and tell the court, do you have any questions for the court?
No, I don't.
Mr. Gera, do you have any questions?
No.
All right, keep in contact with your lawyers, and then the master, Mr. Perez, now appointed by the court, will be contacting your lawyers. He'll be setting up some meetings. I don't want to say court hearings, but they're legally enforceable as court hearings. You'll present evidence and testimony, and he'll prepare findings in a report, and that report will get sent to the court. This is going to save you a lot of time, and because of that, probably a lot of money too. And then your lawyers can approve that or dispute that before the court. So, Ms. Flores, give the court a final hearing date in April.
April 16th at 2 p.m.
I'm sorry, ma'am, was that 16?
Yes, April 16th at 2 p.m.
And Your Honor, just for clarification for the order, does that report also include the preparation of the deed, the master and chancery deed that conveys that property? That was the request. So the request is to appoint a master and chancery to prepare the deed that Mr. Guerra refuses to prepare.
Can the court legally give a master that responsibility?
Yes, Your Honor. So the Rule 171, Judge, of the Rules of Procedure say that the court in exceptional cases and for a good cause appoint a master to have such power as the court provides in order to take all measures necessary for the proper and efficient performance of his duties and do what the other party refuses to do. And so...
Where does it say that?
Well, it says that under the orders of the court have such powers the master and chancery has in a court of equity. The order of reference to the master may specify or limit his powers and may direct him to report only on particular issues or to do or perform particular acts. And so the act that I'm seeking is that in the stead of Mr. Guerra, who refuses to sign title to the equitable owners, that the master be empowered to sign a master and chancery deed in the stead of Mr. Guerra. That is the purpose of doing it.
And Your Honor, if I may respond, I think it would be in the party's better interest to go ahead and make the report, if that's what he's going to be appointed to do. Make the report, provide that information to the court, and then be able to maybe help the parties work with each other better after that report has been made. Again, I stand by my client, Ernesto Guerra, was not given due process. And to have a master, I mean, he could have at least listened to my client's position.
And on page 3, Judge, of my motion on paragraph 8 and 9, it specifies the authority that I'm asking the court to vest the master in order to perform the actions that Mr. Guerra refuses to perform.
And again, how can you refuse if he wasn't even served with notice, or if he wasn't served as a party? He wasn't given due process. He couldn't because he wasn't a part of it.
All I'm asking, Judge, is for the merger of equitable title and the title. And as I said, the equitable title has already been decided by the court. It's inherent in the court's ruling. It wouldn't have made that ruling if that was not community property at the time back in 2017 that the parties under oath agreed to this, and the court signed a decree to this effect. And so it's just basically what amounts to a ministerial act of getting a deed and signing over to the equitable owners what is rightfully theirs. Mr. Guerra is here before the court under the court's jurisdiction. Mr. Guerra continues and refuses to abide by that judgment. And so that's why the purpose of the master in this exceptional circumstance is to comport with the parties' agreement, the court's judgment, and merge the equitable and the title in these two people before you.
I mean, I think at this point, we're just going around in circles. Again, my client's position is no.
I agree.
Yeah.
All right. The request for all the reasons stated on the record is well taken, subject to Mr. Perez making that report in writing and filing any objections to the request if in his review he feels that he shouldn't have that authority. Subject to those two things, it's well taken and so ordered. Include that language in the orders that are due to the court honor before February the 23rd. We'll come back. Obviously, I'll be monitoring the case. I suggest if Mr. Perez doesn't, whenever that report is filed with the court, I'm not going to get notice. The court only gets notice on fiats and orders. So file something, a fiat or an order, so that it's at least on the court's radar whenever that report is prepared. And then we'll come back as necessary on April 16th at 2. Anything else on this case, Mr. Tames?
For purpose of the order, Judge, how much time should we give Mr. Perez to prepare that report?
So February the 12th, I would say 5 to 6 weeks should be sufficient, at least 2 to 3 weeks before the final hearing date, to give both sides an equal opportunity to respond, object, and do whatever you need to.
Okay.
Any objection to any of this, Ms. Aldana?
Just for clarification, it's the report and filing of the objections would be due 2 to 3 weeks before the trial, right? And what's due on April, and the order that
you're right. Let me be very specific. The report of the Master in Chancery is due to the court honor before March 27th at 5. The objections, unless there's a statutory or rule that controverts what the court's about to say, any responses or objections are due to the court honor before April the 10th at 5 p.m. That gives you both sufficient notice of your positions and you're not surprised in court. Thoughts, comments, or objections, Mr. Tames?
Just for clarification, March 27th, is that correct, Judge? The audio kind of cut out a little bit.
That's the date the report is due, and any objections thereto are due April the 10th by 5.
And just for the clarification on the master's report, it is to report back to the court on the legal issues presented to you today. Is that correct?
Yes.
Gotcha. Okay.
I mean, the request is granted in full, subject to that report and subject to Mr. Perez objecting to any of this. Thoughts, comments, questions, concerns, or objections, Ms. Saldaña?
No, Your Honor, subject to Mr. Perez object, right?
He may feel differently, and that's fine if he does. If he does, I want to hear it. All right, Mr. Saucedo, Ms. Guerra, Mr. Guerra, keep in contact with your lawyers, and the master will soon be sending you, ostensibly, some notices to appear or to provide some information that's going to help him make some decisions on that report in this case. Mr. Saucedo, Ms. Guerra, Mr. Guerra, I wish you all very well. Have a good day.
Thank you, Your Honor.
Thank you, Your Honor.
Any other cases for either counsel?
That is all, Your Honor.
It's good to see you both. Have a great day.
Thank you, Your Honor. You too.
Ms. Flores, have all cases been called on today's docket?
Yes, Judge, all cases have been called.
All right, this now concludes this docket held in person and by video conference for Thursday, February 12th, 2026. The court continues to embrace the latest technology to provide safe and uninterrupted access to justice without delay. Today's docket was made possible by the appearance of counsel and parties and by the assistance, diligence, and preparation of the Webb County Court at Law 2 staff and the employees of Webb County that provide judicial support to the court. For those still present from the clerk's office, our interpreter, and the sheriff's office, I thank you all. Have a great day.